So we're going to kick it off now. Seems much less formal than I thought it would be, given the numbers. But good morning. For those of you who don't know me, my name is Mari Stewart, and I'm the head of legal operations and strategic initiatives here at Sanctum. Welcome, and thank you for joining us this morning for our Privilege in Practice DLE, which is going to be presented by Penny, who's a partner in our litigation and dispute resolution practice group, and Mushan Wahaj, who is an associate in the practice group as well. For those two people from Stikeman Elliott, please make sure to sign the registration form for your CPD hours. For those guests not from Stikeman Elliott, don't worry, we've got you covered for the tax over here. So with that, I will turn it over to you guys.
Thank you. Good morning, everyone. Welcome. So Mushkan and I are going to be covering the whole gamut of privilege law in the next 45 minutes or so. So a lot of it will be general principles, but what we've tried to do is include specific examples from cases to kind of try to ground some of those general principles. But at the end of the day, if you have a privilege issue that has to be litigated or determined by the court, it's always on a case-by-case basis. So it's always, the court has to look at all of the cases, and it's it tends to be very case-specific. We were going to save time at the end for questions, but I think we're a small enough group, so if you have any questions, just feel free to ask them as we go. In terms of an overview, so we're going to cover the general principles on the types of privilege, waiver. We'll look at some cases, particularly in the context of common interest privilege, and then we'll look at the line the courts have drawn in terms of business advice versus legal advice when it comes to in-house counsel, and then we'll talk about some practical considerations for some common situations that come up for in-house counsel. As a starting point, just talking about privilege and confidentiality. So while they're related, they're different concepts. Solicitor-client privilege protects all the communication that a client has with their lawyer. It's a substantive rule of law. It's akin to a constitutional right. And it's really there and necessary for the administration of justice. The duty of confidentiality that a lawyer has to their client, it covers not just communications, but any information that the lawyer receives or learns in working with a client. And it's an ethical duty. It's addressed in all of the codes of conduct of the various law societies. And confidentiality doesn't necessarily protect disclosure of documents the way that privilege does as a rule of law. Types of privilege, which I think this is a refresher. Most of you will be familiar with all of these concepts. So there's two types, what are called class privileges and case by case. And your class privileges are the one that you are familiar with: solicitor-client privilege, settlement privilege, and litigation privilege. Essentially what class privilege means is it applies to the type of relationship at issue, and it applies in all cases unless there are exceptions. Case-by-case privilege is where the courts have left open the ability to recognize new applications of privilege on a case-by-case basis. There's a four-part test that the Supreme Court has set out from the Wigmore test. It's called the Wigmore test. And the court will apply the four-part test to determine if there is case-specific privilege. And the four parts are: it has to be a confidential communication. Confidentiality must be essential to the maintenance of the relationship between the parties. The relation must be one which ought to be fostered, and injury that would result from disclosure must be greater than the benefit. And it doesn't usually come up in sort of our commercial practices, but one example that I thought was interesting where the court considered case-by-case privilege was in the context of a professional negligence case against a law firm. And the issue was whether communications internally within the law firm about that potential liability and the advice that the internal committee gave with respect to that potential lawsuit, whether that was privileged. And so it was a circumstance where the court applied the four-part test and came up with a quality assurance privilege that applied in that case based on the Wigmore criteria. And basically, the court found that quality assurance where the law firm is giving itself advice to ensure that the work that it did was, met what was a sufficient quality is a type of privilege that, again, if the four criteria is satisfied, that can apply, but it was done on a case-by-case basis. So solicitor-client privilege, first-class privilege that you'll all be familiar with, requires communication between solicitor and client. And what's interesting or what's important here is that as a general rule, the communication is protected, but the underlying facts are not necessarily protected and they could be subject to disclosure. You need, obviously, the seeking or giving of legal advice, and we'll get into some examples, but for example, if you've just copied a lawyer on a communication, it doesn't necessarily make the communication privileged if it does not have, or it's not part of a set of communications that have to do with the seeking or giving of legal advice. And obviously, it has to be intended to be confidential. So as an example of, facts versus communications between solicitor and client, the court has held that a lawyer's real estate transaction file and its related records, including accounts and ledgers, were not protected by legal advice privilege because they were records of the particular transaction and they weren't a communication for the purpose of seeking or giving legal advice. That now, in terms of the seeking or giving of legal advice, if there are documents that are exchanged, and maybe the content of the documents themselves do not contain legal advice, but the documents are exchanged or provided to a lawyer for the purpose of seeking legal advice, those documents can also fall within the protection of solicitor-client privilege. So if you're, for example, providing documents that are not inherently privileged, but it's provided as background to in-house counsel in order to get legal advice, and you label it as, these documents are being provided for the purpose of getting legal advice, then you can extend privilege to the documents that you've provided into that communication. Solicitor-client privilege is permanent in duration. It does not end when legal representation changes. It does not end when the client dies. It is permanent, and the only way, and we'll get to it, that you can that it ceases is when it's waived. And there are very, very narrow exceptions, which again don't necessarily come up in our practice, but you can't maintain privilege over communications that are in furtherance of a crime or pose a threat to public safety. So litigation privilege is another class privilege that applies to documents or communications that are created, gathered, or annotated in contemplation of litigation, and litigation has to be the dominant purpose for their creation. So it's not as equal to or broad as solicitor-client privilege. And the reason for litigation privilege is that it arises from the adversarial system that we litigate in, which allows the party to control how to present its case and decide what evidence it will use to prove its case. without having their preparation be disclosed in the litigation. So it's intended to create what's called a zone of privacy within which counsel and the party can work and strategize with respect to a piece of litigation. There's quite a bit of case law on what dominant purpose means. So what is the dominant, were the documents created for the dominant purpose of litigation? Litigation doesn't need to be the only purpose of the communication, but it has to be the primary purpose. Courts have held that documents that may have been created, for example, in the course of operations in any event, don't necessarily become subject to litigation privilege because there also happen to be litigation outstanding that the company was dealing with. So a few examples of documents that were found not to be subject to litigation privilege. So a report prepared after an accident, for example, for the purpose of establishing the cause of the accident, was not subject to litigation privilege because it would have been prepared otherwise. So, and we'll get to some of this when we get into the practical tips. It's very important if there is litigation privilege to be applied. Like, first you need litigation. It can't just be, and it can be contemplated or threatened, but there has to be some contemplation of litigation, and the document has to be prepared for the dominant purpose of that litigation. So it's important to, if litigation is not something that's contemplated, but as soon as it is, it's important to document that in the file so that in addition to maybe solicitor-client privilege, you can also rely on litigation privilege. And in terms of solicitor-client versus litigation, solicitor-client privilege protects the relationship, whereas litigation privilege is to ensure the efficiency of the adversarial process. And as we talked about, solicitor-client privilege is permanent, whereas litigation privilege is temporary and ends when the litigation ends. Litigation privilege does apply. It's not just solicitor-client communications, but it can apply to communications with third parties. It can apply to communications not involving counsel, as long as it's related to and is a dominant purpose is with respect to a piece of outstanding litigation.
So for litigation privilege, the group who has access to that document has to be relatively close, it's still confidential, or very close.
So I would say, as I think with any documents, and we'll get into this, especially for in-house counsel, anything to do with your advice, with litigation, it's better to keep a smaller group, right, as opposed to a wider circulation. But I don't think that's necessarily effective. So let's say you have an outstanding piece of litigation, in-house counsel prepares a memo, this is our strategy, this is the experts we've retained. Even if you have circulated that broadly, if the substance of the document relates to the litigation, it could also be in-house counsel has retained a third-party expert to assist with the litigation and provide their views on the litigation. Again, as long as it's clear, we've retained the third party to assess our exposure in this piece of litigation. That is a document created with the dominant purpose of the litigation, then it would be covered by privilege. And then we'll move on to settlement privilege. So settlement privilege applies to negotiations or without prejudice exchanges. It's distinct from legal advice and litigation privilege. And settlement privilege is really there to protect the interest in promoting settlement discussions and avoiding litigation where possible. So you have to have a litigious dispute and communications within the context of that dispute in an attempt to effect settlement. Sometimes we see communications where there is a without prejudice label, but the substance of the communication doesn't really contain any hint of compromise or negotiation. So just because we put without prejudice label on something doesn't necessarily make it privileged. There has to be some element of an attempt to negotiate an existing dispute or an attempt to, it may not necessarily be an offer to settle, but it has to have some kind of offer of compromise. So you can't just put without prejudice label on a letter and assume that settlement privilege applies. There has to be a dispute. It has to be part of an effort to deal with that dispute. It applies to both parties, and it cannot be waived unilaterally by one side. And I've been speaking a lot.
Does that
Yeah.
apply to phone conversations, verbal communications?
Yeah, absolutely. So it covers. So it's always good practice, right? It's good practice to start to always say that, and we always put it on written correspondence as well, right? So I think it's good practice, and then also making a note that was stated on the call, and then it's very clear. So I'll turn it on to Mujgan, who's going to deal with waiver and a few other topics.
Hi, everyone. Thanks, Sam. So I think the big question on everyone's mind as a lawyer is probably, how do I lose my privilege? And there are generally two types. The first is voluntary waiver, and that's where a party voluntarily discloses privileged information to a third party. And then there's implied waiver, and that's the nightmare for us all. But luckily, the test for establishing waiver of privilege is a very high burden. Courts are quite reticent to recognize a waiver unless it's expressed and explicit. And the Supreme Court has actually said that it should only be deemed implied waiver where it's absolutely necessary, and applying as restrictive a test as may be formulated, short of an absolute prohibition in every case. And the basis for that is just the significance of privilege in our legal system and in the functioning of our judicial processes, like Sam was just mentioning. So when it's narrowly construed in this way, the typical application of implied waiver comes in the context of the state of mind of a party. How that comes up is, say, in a pleading or in the course of litigation, someone puts into issue their state of mind, their knowledge and awareness of something, or anything that pertains to their state of mind, and something that legal advice could potentially go to. And that typically prompts opposing parties to bring a motion to seek further information on the basis that that issue has now been put into issue in the litigation. And so in that context, when it's narrowly construed, the courts, particularly recently in the British Columbia Court of Appeal, they've said that the test requires more than just putting the state of mind into issue. It also requires more than just alluding to legal advice. What it requires is that the parties intentionally and voluntarily inject into litigation legal advice that has been received, or its understanding of the law before implied waiver can take effect. So I guess the gist of that is that it's very difficult to prove implied waiver. There has to be something that suggests that a party is voluntarily taking steps to waive privilege. One exception to that rule is common interest privilege, and I know that's an area of interest for most of us. So
before you move on, I just want to make a comment on waiver. So one thing to keep in mind is if you do decide, and there are circumstances where you may decide to waive privilege over something. So what to keep in mind is there's no such thing as partial waiver. So if you do decide to waive privilege, it's really important to know that you're not waiving privilege just over a specific document. You're waiving privilege over that category of advice. So and there are circumstances where a decision might be made to waive privilege over a certain document. But if you're, for example, if you got advice on employment law to do with a transaction, and you decide to disclose that advice to an advisor within that transaction. And we'll come to whether privilege can be extended. But if it's found that there has been waiver, the waivers with respect to the entire advice related to employment law within that transaction. So you can't just pick and choose what you waive privilege over.
No problem. Another scenario to be mindful of is the concept of limited waiver, and that applies in the context of auditors typically, so or other legislative requirements for disclosure. So essentially, when you're looking at an auditor's case, right, you have to disclose all documents that the auditor needs or requires to complete their function or mandate. But that doesn't constitute necessarily a waiver of privilege, even though you're disclosing privileged information to a third party. What courts have considered that to be is a limited waiver to an auditor for that specific purpose of performing the audit function. And that privilege cannot then be waived again by the auditor. It remains with the client. So it's not really captured by implied waiver or voluntary waiver. And so there's this niche area of limited waiver, which doesn't really exist anywhere else. Now, the most common exception, I think, to waiver of privilege of interest. Oh, yeah, go ahead.
Did I just jump back to that point?
Sure.
Presumably you need to notify the auditor that you're going to the privilege law, right?
Yeah, I think that's to Sam's point, the best practice is always to make sure that your documents which are privileged are noted as such, and that there is conscious awareness that you intend to maintain privilege over documents, even in this context. But again, to Sam's point earlier, privilege is something that applies automatically. It's not something that you need to necessarily state in order to invoke. So even if you don't do that, that doesn't necessarily mean it's fatal to your claim of privilege. So common interest privilege is something we're all typically familiar with. It's also referred to sometimes as deal team privilege. It's the kind of thing that applies when there is an existing underlying privilege to protect, and that information is shared in confidence with a party with whom you have a common interest. And so that's why it's relative to deal teams, because you'll typically be working with different types of entities, whether that's opposing counsel or a different commercial entity, financial advisors, things like that, where there's a common interest in the provision of legal information or information that might otherwise be privileged. It's an exception to the doctrine of waiver, but it isn't a standalone ground for privilege. So something won't attract common interest privilege on its own. What it does, common interest is an extension of existing privileges. So if a document is on its face solicitor-client privileged, and then you go ahead and share that with another member of the deal team, then that's the privilege that's protected by common interest. It doesn't create a novel area of privilege. What's important for establishing common interest privilege is the existence of a sufficient common interest. And so what does that mean? It means that there has to be pending or anticipated litigation where two or more parties are seeking to defend their interests against a common party, or privileged information is shared further to, say, a commercial transaction. So the first category, pending or anticipated litigation, you might find that co-defendants will share materials in litigation in furtherance of their joint defense. Or you might have cases where you're in common interest with another legal entity or another expert entity or whatever the case may be in furtherance of your defense in that litigation or in furtherance of your involvement in that litigation. Whereas the
You're going to be in common interest on all issues, like the entirety of the case, as you will have to be co-defendant, or can it be aligning purely on one component of the case you can exercise common interest?
So I think it depends on the nature of the conflict, right? I think if there's enough of you can't just be on common interest on one narrow part of the case, right? What the courts have, what drives sufficient common interest, it's what the courts refer to as self-same interest, right? So to me, self-same interest is you have the same goal with respect to the litigation. And I think it will be more difficult if you have areas where you're not in common interest to then try to say you're in common interest with respect to the entirety of the litigation. And one thing I want to note about deal team privilege is the law is not settled. So that was sort of in the context of litigation. In the context of deal team privilege, it first of all, it doesn't apply automatically. It applies on a case-by-case basis. And, we have, for example, a case that Mishkan will get into in the context of a tax advice given within the context of a transaction, right? So in that case, it was very clear it was tax advice from lawyers for one party shared with the other party on a common interest basis, and the court finds that there was sufficient common interest. However, what we see in practice, and we get a lot of calls in the transaction context, is, well, can we share something with a financial advisor? Can we share something with a lender, right? And I think in that context, it's not settled that there will be deal team privilege, and there are ways we'll talk about in trying to, so either you don't share, or what you share is subject to certain protections, including, for example, we will often, when a financial advisor is involved, you have counsel retain the financial advisor. You have terms which assert within the retainer that confidential information may be shared, privileged information may be shared, and that if information is shared, it's shared on a common interest basis. But in terms of where the law is, it's not settled that you can just share privileged advice with a deal team and have protection automatically.
And there's also additional relationships that might attract that common interest privilege. Now, to Sam's point, the area is certainly not settled, so this is once again a case-by-case assessment, but the courts have found circumstances wherein there's a trustee-beneficiary relationship or a fiduciary relationship of some sort that might also be sufficient to attract a sufficient common interest. So going to the case that Sam just mentioned, this was a recent Federal Court of Appeal case. Well, it's 2018 isn't that recent anymore, but this case caused a lot of tension, I think, on the street because so essentially what it involved was a joint memo that was prepared by counsel to a commercial transaction. It was the context of a series of acquisitions. They then shared that memo with their respective clients. And the Minister of National Revenue then demanded production of that legal opinion, that memo. Counsel claimed privilege. They claimed that the memo itself was solicitor-client privileged and then exercised common interest over that. But the Minister of National Revenue argued that, they had intentionally disclosed that memo after it was prepared to parties who would be, either adverse in interest or parties who are third parties to that client-lawyer relationship. And therefore, that was a waiver of privilege. The lower court, the federal court itself, held that a common interest privilege is an adjunct to standard solicitor-client privilege and will not apply in commercial transactions where information is shared in a non-litigation context. More importantly, they also said that common interest privilege really can't apply unless there is that litigation context. That upends pretty established case law in Canada about common interest privilege. It's well recognized in Canada. So this is why it created so much tension on the street. 2 years later, the Federal Court of Appeal overturned that decision and admonished the trial court for ignoring decades of Canadian jurisprudence in favor of recent American case law, which was the basis for the lower court's decision. The Federal Court of Appeal essentially said that disclosure of the memo to other parties to the proposed transaction did not result in a waiver of privilege at all. It was the communication of the memo was strictly limited for the purposes of that transaction, and it was shared with parties who had a common interest in that transaction. And in any event, that sharing that information was beneficial to the operation of the business and operation of that legal relationship between the parties. Sharing opinions relating to complex issues like tax or complex statutes like the Income Tax Act could lead to efficiency in competing transactions, and clients would be better served. So other recent development, not recent again, other developments in Canadian case law that I guess is more recent than the historical standards on privilege include recent legislative decisions regarding legislative demands for disclosure of privileged documents. The first case of two that were released contemporaneously in 2016 is Alberta and University of Calgary. The case involved a former employee of the University of Calgary who sought the disclosure of certain records under the Provincial Freedom of Information Act. The university withheld those records, maintaining that they had exercised solicitor-client privilege over them. And so the delegate of the Privacy Commissioner then said, well, let us have those records, the solicitor-client records, and we'll make the determination as to whether or not that privilege is rightfully asserted. The university rejected that proposal and sought judicial review of the Privacy Commissioner's decision. The Supreme Court held that solicitor-client privilege can only be statutorily abrogated by legislative language that is clear, explicit, and unequivocal. It needs to directly say that it will apply to the class privilege, to solicitor-client privilege, litigation privilege, settlement privilege, whatever it may be, but it cannot apply in circumstances where the legislation seeks to target, as it was in this case, privilege that is a law of evidence, which solicitor-client privilege is not. It is a substantive right. So where, in what circumstances could, for instance, this requirement to disclose apply? Well, it could apply in contexts like spousal communication privilege or religious communication privilege or even settlement privilege that operates in the context of that operates exclusively in the context of the litigation itself in a court proceeding, because then that becomes a law of evidence distinct from a class privilege that attracts a presumptive right of privacy. So, conscious of the timing, the next case is important. It's on similar issues, Lizotte and Aviva Insurance. Again, a regulatory body sought disclosure of documents that were deemed privileged by the insurer. The regulator challenged the insurer's claim to the privilege. They had claimed litigation privilege. And the regulator said, well, you know, legislative requirements operate to lift litigation privilege, which is less important than solicitor-client privilege. The Supreme Court unequivocally rejected that idea, stated that litigation privilege is in fact a class privilege, and it's of critical importance to the public interest because it ensures the efficacy of the adversarial process. They said that the open-ended language of the regulation, which required disclosure of any document, was not sufficiently clear, explicit, or unequivocal in order to abrogate a class privilege. So the key takeaway from this is litigation privilege, though distinct and separate from settlement privilege or solicitor-client privilege, will still attract a presumptive right of non-disclosure. I'll pass that off to.
So in terms of in-house counsel, the case law is very clear that all of the privileges we've been talking about applied equally to advice and activities of in-house counsel. That because the lawyer works in-house instead of being external does not affect the creation or the character of privilege. You know, in terms of in practice, obviously, and we'll talk about some of this, in-house counsel is often called on to provide both legal advice and business advice, and it may be difficult to delineate the two, and we'll look at some cases with respect to that distinction, but often, as I said, these determinations are often made on a case-by-case basis, and sometimes the court will actually look at individual documents. So the court will look at individual documents for the purpose of determining whether they contain legal advice or what can be characterized as business advice.
So I think one of the most important cases to know when it comes to in-house counsel in the exercise of privilege is Pritchard. It's a 2004 Supreme Court of Canada decision. It concerned a former employee who filed a human rights complaint with the Commission against her former employer, and then sought judicial review of the Commission's decision not to investigate her complaint. The Commission refused to produce certain documents which had been prepared in respect of that decision, including a legal opinion that was produced by in-house counsel to the Commission, citing solicitor-client privilege. The Supreme Court upheld the claim to the solicitor-client privilege, noting that in-house counsel often wear both business and legal hats, and so the determination of privilege has to be assessed on a case-by-case basis, depending on the three factors: the nature of the relationship, the subject matter of the advice, and the circumstances in which it's sought and rendered. So essentially, you're looking at the pith and substance of what is communicated. For it, solicitor-client privilege to apply, the communication or record has to be of a legal nature. This includes seeking or giving legal advice, but it also includes documents that belong on the continuum of the legal advice. So the content of the documents that kind of inform the content of the legal advice, or how that legal advice is shaped, back and forth regarding, or discussions regarding the legal advice, all of that would be captured. And it's not important that in-house counsel have a different role to external counsel in this context. Solicitor-client privilege will continue to apply, provided that the communications and issue contain legal advice. Other principles that are of note for in-house counsel from case law across Canada, but particularly Ontario, include a case, Humberplex Developments. It's very often cited for the principle that operational communications can't be cloaked in privilege by copying them to a lawyer. So Humberplex is a case about a motion to compel almost 1,000 documents over which the party had claimed privilege and listed on their Schedule B on the affidavit of documents. They stated that it was part of the continuum of communication between corporate employees, in-house counsel, and external counsel. And the court rejected that principle, saying that, well, you can't just say that everything is privileged just because lawyers are copied on it. It's not part of the continuum of legal advice just because a lawyer is copied on an email. There has to be, like I said, in pith or substance, there has to be a discussion of or relation to seeking or giving legal advice to attract the privilege. It's a numbered Ontario company, but it's AlphaCare and versus the City of Toronto. They considered whether, the case is quite interesting, actually. It considered a bylaw that had been enacted restricting the operating hours of something called body rub businesses. Not sure what that really means, but the city solicitor prepared a report on the validity of the bylaw, and then that report was later leaked to the businesses, who then provided that to their counsel. The business's lawyer held on to that report for 2 years without telling anyone that he had it, and he used that report to inform the application to strike the bylaw. When it came out that he had this report on hand, the court didn't take kindly to it because the report was solicitor-client privileged, and the fact that it had been leaked to the businesses was not a waiver of privilege. In the end result, the report was returned, the solicitor for the business was removed, and the application was struck on that basis. So the key principle that came out of that case is that where counsel communicates factual information together with legal advice, the entire communication is privileged. It doesn't require you to kind of redact only the legal advice. The facts that inform it are also part and parcel of the privilege, but that privilege will only attach to the communication. The underlying facts, if they can be obtained from another source, will not be privileged. So if a party can find it on the internet or can go elsewhere and get it, that the facts themselves will still be available for use in the litigation, just provided that they get it from somewhere else and not from the solicitor-client communication. So lastly, there's an interesting case called Labbé and Allen Vanguard about transactional due diligence. Essentially, the lawyers in that case took the position that due diligence is a legal process, and so all documents that related to due diligence are privileged. And I think part of this was because it was such a large production, so their initial view was, let's just mark all of these as privileged because it's due diligence. The court naturally did not appreciate that sweeping take on the concept of privilege, stating that the blanket position was inappropriate and had inappropriately exercised privilege over documents that had simply been part of a business decision. The idea being that when you're conducting due diligence in a transaction, you're not actually doing legal work. You're informing yourself for the purposes of a business decision, being, you know, whether to make an investment or whether to pursue an acquisition or whatever the case may be. The only time that will attract privilege is on the ordinary concepts of privilege. So if there's a lawyer involved who's giving or seeking, or who's giving legal advice, or if you're seeking legal advice, conversations about legal advice, those kinds of things within the due diligence might attract privilege, but as a prima facie rule, it's not going to attract privilege on its face.
Okay, so some specific issues that might come up for in-house counsel. The first one is jurisdictional issues. In-house lawyers may be called on to provide advice with respect to a jurisdiction that maybe they haven't been called to practice. And the prevailing view is that the advice will be covered by solicitor-client privilege, even if the lawyer is not licensed to practice law in the jurisdiction where the advice is given. And this arises from the, the reality of particularly clients that operate in multiple jurisdictions. They may turn to their lawyer in one jurisdiction to help coordinate legal advice in another jurisdiction. And so that's a practical reality. And just because a lawyer in Toronto may not be called to give advice in the U.S., but they're coordinating litigation in the U.S. and Canada and elsewhere, that advice is protected by solicitor-client privilege. Another issue that comes up is with respect to in-house counsel, perhaps within the parent company giving advice to subsidiaries, or legal counsel within one corporate entity giving advice to an affiliate. There is case law which states that in the case of a parent-sub relationship, a sub will be considered to be a client of the in-house lawyer if the sub is wholly owned by the parent, the interests of the sub and the parent are closely aligned, and the companies are sufficiently intertwined to consider employees of the sub to effectively be employees of the parent. This can raise some, but we don't have similar case law, and this doesn't apply to where you're providing advice to an affiliated entity. And so one way, and also you have to keep in mind, even in the parent-sub relationship, as if there is any divergence of interest or if there's any conflict within the parent and the sub, then again, the in-house lawyer cannot be providing advice to both entities. So one way to deal with this is to have essentially a joint retainer arrangement in place where the in-house lawyer is jointly retained by both entities, and the terms provide that everything is subject to common interest privilege unless and until there is a conflict of interest, and in that case, the retainer specifically provides that the lawyer will continue advising one entity, and the other entity will have separate counsel. And that's one way to deal with issues that might come up within corporate structures. Another area where issues may come up for in-house counsel is with respect to internal investigations or responding to incidents or crises that might come up. In-house counsel are the first call to deal with these issues. What's important to keep in mind is that when it comes to investigations or reports of investigations and related communications, they're not necessarily all subject to privilege. And so, you know, often there isn't, for example, existing litigation or threatened litigation or even existing regulatory investigation. And in that circumstance, you can't rely on litigation privilege because there's no contemplated litigation. So what's available is solicitor-client privilege. And in order to be able to assert solicitor-client privilege, there has to be sufficient link between the investigation and the seeking or giving of legal advice in order to be able to assert solicitor-client privilege. It is, again, a court take case-by-case approach. One example is, for example, interview notes. So if you're an in-house lawyer and there's been an incident that you're looking into and you are taking notes of that interview, it's important to, one, ensure that you've recorded that it's in-house counsel conducting the interview, and that you know, the notes reflect not just the facts that were gathered, but counsel's impressions. Again, to create that continuum of legal advice. The company has asked you as counsel to investigate the incident. You have prepared your notes and you prepared a report in order to be able to advise the company, provide legal advice to the company. One interesting case from a few years ago is it's a decision from the Ontario Privacy Commissioner. It was in the context of LifeLabs had a cyber attack in 2019. And what they did was they had a third party to investigate the hack. They had the third party communicate with the hackers. And there was a lot of material generated in that context. There were reports and so on. And the Privacy Commissioner asked for disclosure of all of that product. And LifeLabs resisted. They claimed litigation and solicitor-client privilege. And the Privacy Commissioner concluded there's no litigation privilege because the documents were not created for the dominant purpose of litigation. The hack had happened. The commissioner looked at it as an operational document because LifeLabs needed to figure out what had happened. And in terms of, and again, they weren't able to assert solicitor-client privilege, given that, again, the documents had been created in responding to the crisis, and they were looked at as more operational. They weren't in that continuum of seeking or giving of legal advice. And so, you know, and one factor that the commission looked at was that the third-party advisor had in fact been retained before the cyber attack, and it was during the course of their testing that they discovered the cyber attack, and they said, okay, this was all purely operational, and then they were retained after on a separate retainer after the cyber attack in order to deal with the issues. And in both circumstances, the view was that this was in there was no. It wasn't in the continuum of legal advice. This was something that the company had to deal with anyway. I think there was a note that there might have been judicial review sought of this decision, but we haven't been able to find whether there's no public decision dealing with the judicial review. So in terms of dealing with these types of situations, if you're retaining a third party, again, as I said, it's important if you can have counsel retain third parties for the purposes of being able to provide legal advice to the company, and to the extent possible, the reports and records that are generated, again, if they are for being able to advise the company and give legal advice, to have that recorded through the retainers, to the reports that are prepared and so on.
Just a question on the corporate structure.
Yeah.
I think that probably comes up a lot. Do you have to have an independent retainer arrangement for every incidence of advice that you're giving? Can you have a general one, even maybe in an employment agreement, or so that it captures everything?
I think you can have a general one. because as in-house counsel, you may be called upon to give advice to an affiliate or a sub in different circumstances. So I don't think you need one for each incident. Although I would say, like, if you had a crisis or some kind of big incident you were referring to, you may want to have one specific to that just to make it clear. But I think in general it would be fine.
Other issues that commonly come up for in-house counsel include, board meeting minutes. It's pretty well accepted that legal advice that in-house counsel provide to the board of directors of corporations or agencies will be privileged. And so where that legal advice is reflected in the minutes of the board meetings, then that's protected from disclosure and may be redacted, though the balance of the board meeting minutes would have to be disclosed. Other issues include internal memos. This operates sort of on the general principle that materials prepared by in-house counsel will be privileged, provided that they're for the purpose of giving legal advice. But there are cautions in the case law that, indiscriminate disclosure of internal memos within the corporation or within the organization could abrogate that privilege or result in the loss of that privilege completely. A recent case that looked at this issue that is of some concern is Toronto TD Bank and Lay Instruments, and
Not that.
not recent. Why do I keep saying recent? So it concerned a memo that was circulated by the bank's in-house counsel to the entire bank branches, communicating that essentially they were talking about the risks that were associated with comfort letters and the acceptability of a comfort letter to the bank as a security. And so when that document was the plaintiff in that proceeding sought to compel production of that document, and TD argued that that was actually an in-house counsel memo that was circulated for the purpose of providing legal advice. And the court held that privilege had been waived because of how broadly it had been circulated, and it had been circulated without any sort of indicia of privilege. It was circulated on corporate letterhead instead of legal letterhead. There was no suggestion that it had been a legal memorandum. It was more so like a letter of instruction almost to the branches. So it had on its face much more of a corporate appearance than a legal appearance. And there was no restrictions or no cautions to the recipients to say that this is confidential. So that's like sort of a caution to in-house counsel, that where you are planning on widely distributing a document or an in-house counsel memo or anything like that, there should be something expressed on its face that makes it look like a legal memorandum, that suggests that it is confidential. The recipients, no matter how many are receiving them, should be cautioned that the contents of that memo are confidential and shouldn't be widely circulated. And that might help to preserve the privilege. Other issues that might be of note are emails. As in-house counsel, all of your emails will not necessarily be privileged. And that's something to bear in mind because, again, that difference between a business hat and a legal hat, what you want to be able to do in circumstances like this is to be able to clearly stipulate where you're acting in a legal capacity versus a business capacity. And so, I mean, I don't know if Sam has other thoughts on this as well, but that might include things like denoting on an email that you are acting as counsel providing legal advice, or that you are acting in your business capacity and providing business advice, where you need to make it clear, because where those things come into issue, it will be again assessed on a case-by-case basis.
And maybe we'll just skip over to, because I know we're over time, we'll just skip over to just the so some of the best practices we've talked about, also recognizing that these communications are often done in a fast-paced environment, so you're not always in a position to be labeling things, but just something to keep in mind. Using labels, provision confidential for advice of legal counsel, those kinds of labels will help. Although you have to be judicial in using those labels. You don't want to stick them on every communication, because then again, if a court's looking at the document and that label appears on every document, then it's not, the label's not going to achieve its purpose. Keeping legal advice on a need-to-know basis. So again, not, avoiding wide disclosure, avoiding, and sometimes you don't need an email, right? You can pick up the phone or Teams or Skype. And these days, even documents can be shared on a screen. So you may be able to share a document without actually sending it or broadly circulating it. One thing to consider is whether you want to formalize any of these practices in terms of a policy that that you can use for training, especially non-legal staff members, right? On when they best practice when they're sending documents to seeking legal advice, and also might having some kind of policy in place might help with implementation. There is keeping separate files, right? So when you have litigation files or legal files, trying to keep them separate from files where you're not being asked to provide legal advice. Avoiding communicating, business and legal advice in the same communication, or having a long email chain where later when someone's doing doc review in the context of a litigation, they kind of have to read it to find, what's legally privileged and what's not. So having, the legal advice provided distinct and separate from longer email chains for our communications. And I think an important point where litigation is contemplated, making sure you've got something in your file that records when litigation was first contemplated, so that there's no issues with asserting when litigation privilege applies.
Other points might be, ensuring expert retainers are addressed to counsel and that they're obtained, noting on the face that they're obtained for the purposes of litigation or providing legal advice. Assigning internal investigations to a lawyer, defining that inquiry as a legal issue, and also giving thought and consideration to whether or not external counsel need to be involved in that process as opposed to in-house counsel. In any event, a memorandum of instruction should be prepared for those investigations, regardless of whether it's in-house counsel doing it or external counsel. And that memorandum of instruction should explicitly assert privilege over the lawyer's involvement and any work product, including the investigator's ultimate report. One thing that kind of Sam just alluded to, like picking up the phone or taking like a Teams call, or just using an alternative channel of communication to an email. Something to be alert to is that it's difficult to apply some of these best practices in the context of novel technology platforms. I don't know if anyone's giving legal advice over Facebook, but one thing to note is that those platforms will not accommodate some of the issues that we're talking about here today, and the informal nature of those mediums makes it a lot more difficult to, I think, preserve privilege over them. So I think a best practice would be to limit your provision of legal advice or reliance on those kinds of external platforms, whether that be Teams messages, text messages, WhatsApp, Instagram, whatever that could be. And in the event that there is inadvertent disclosure, you want to act immediately. And what that could mean is, immediately demanding the return and destruction of the inadvertent disclosure, flagging that internally, raising it however you need to, in order to be sure that it's clear that the disclosure was inadvertent and that the party who received it inadvertently should not be relying on it in any way.
Thanks, everyone. That's it. Any more questions? Happy to take them, but we've gone a little bit over time.
I think, with the last few slides, there were pretty good practices. Maybe we can package them and share them with those of you that attended. I but no, thank you very much for doing this, and thank you very much for joining us.
Thank you.
Thank you.